Current affairs. Let's begin without any delay. National Disaster Response Fund. The NDRF, established under Section 46 of the Disaster Management Act 2005, is a fund managed by the central government to address emergency response, relief, and rehabilitation during threatening disaster situations or disasters. It supplements the SDRF of a state in case of a disaster of a severe nature, provided adequate funds are not available in the SDRF. The fund is placed in the public account of the Government of India under reserve funds not bearing interest, enabling the government to utilize it without parliamentary approval. NDRF is financed through a cess levied on specific items. National Disaster Relief Fund is financed through a cess levied on specific items subject to excise and customs duty, approved annually through the Finance Bill. Additional funding requirements beyond National Disaster Relief Fund allocations are met through general budgetary resources, ensuring continuous support for disaster relief efforts. The fund's utilization is overseen by National Executive Committee (NEC) of the National Disaster Management Authority (NDMA), with annual audits conducted by CAG, Comptroller and Auditor General of India, to ensure transparency and accountability. What are the challenges faced by states regarding disbursement of financial aids? Delayed and insufficient disaster relief. Lack of coordination between the center and state in the disbursement of disaster management funds, NDRF and SDRF. Concerns over the center's unilateral decision making in determining the quantum of disaster resistance. Lack of clear, transparent, and objective criteria for the center to determine the quantum of disaster relief and rehabilitation assistance to states. Absence of enough institutionalized mechanism for states to challenge the center's decision on state disaster aid, imbalance in center-state disaster management framework, perceived over-centralization of disaster management powers and the decision-making authority with the center, concerns over the NDMA being overly dependent on the center and lacking effective representation of the states, lack of flexibility for states to customize disaster response and mitigation measures as per their local contexts and priorities. Centralized planning. The centralized planning may not always take into account the unique needs and circumstances of each state, leading to inefficiencies in the response to disasters or other situations requiring aid. Political dynamics. The political dynamics and relationship between the central government and the state can influence aid distribution, sometimes leading to allegations of bias or favoritism. Lack of consultation. The center is often accused of not adequately consulting the states while formulating policies and schemes, leading to implementation challenges. Instances of the center unilaterally imposing decisions on the states without their consent have been a source of friction. The lack of effective institutional platforms for regular dialogue and dispute resolution between the center and the state, weakening of federal spirit and collaborative approach in the face of growing competitive and adversarial politics. Expanding the OCI card scheme. Why in news? Recently, India has been contemplating extending the Overseas Citizenship of India (OCI) card privileges to overseas Indians in Fiji and other nations after relaxing the rules for Suriname. In 2023, India announced an extension of the eligibility criteria for OCI card of the original Indian immigrants in Suriname from the 4th generation to the 6th generation. Why is Overseas Citizen of India card? What is Overseas Citizen of India card? The concept of OCI was introduced in response to demands for dual citizenship by the Indian diaspora, particularly in developed countries. The Ministry of Home Affairs defined an OCI as a person who was a citizen of India on 26 January 1950 or before 26 January 1950, or was eligible to become a citizen of India on 26 January 1950, or is a child or grandchild of such a person, among other eligibility criteria. According to Section 7A of the OCI card rules, an applicant is not eligible for the OCI card if his parents or grandparents have ever been a citizen of Pakistan or Bangladesh. The category was introduced by the government in 2005. The Government of India, via the Citizenship Amendment Act 2015, merged the person of Indian origin PIO category with the OCI category in 2015. Historical background: the OCI card scheme was launched during the Pravasi Bharatiya Divas in 2005. It was introduced as an acknowledgement of the persistent emotional attachment of the Indian diaspora to their country of origin. Limitations and restrictions: they do not have the right to vote. They cannot hold constitutional offices or government jobs. They cannot purchase agriculture or farmland. OCI card and civil rights. The OCI card does not confer political rights. Holders cannot participate in elections or hold public offices, reflecting the government's stance on maintaining clear boundaries between citizenship and overseas citizenship. Benefits of the OCI card: multiple entry, multi-purpose lifelong visa to visit India, exemption from registering with the Foreigners Regional Registration Office FRRO, Foreigners Regional Registration Office FRRO, exemption from registering from Foreigners Regional Registration Office regardless of the duration of their stay, priority with non-resident Indians NRIs in financial, economic and educational fields. Current scenario: the OCI card scheme has been a key element of the Indian government's effort to deepen its relationship with its diaspora. As of March 2020, the Home Ministry had issued over 3.5 million OCI cards. According to the Ministry of External Affairs (MEA), this number had exceeded 4 million by early 2022. The vast majority was issued to foreign nationals in the United States, United Kingdom, Australia, and Canada. The focus on expanding the OCI card scheme highlights India's efforts to engage with and support its overseas Indian communities around the world. Person of Indian origin PIO. PIO refers to a foreign citizen except a national of Pakistan, Afghanistan, Bangladesh, China, Iran, Bhutan, Sri Lanka, Nepal, who at any time held an Indian passport, or who or either of their parents, grandparents, or great grandparents were born and permanently resident in India as defined in Government of India Act 1935, and other territories that become part of India thereafter, or is a spouse of a citizen of India or a PIO. Voter verified paper audit trial. Why in news? Recently, the Supreme Court announced that it would soon address petition for 100% verification of voter verified paper audit trial slips just ahead of first phase of voting on 19 April 2024. What is VVPAT machine? About: the VVPAT machine is attached to the ballot unit of the electric voting machine (EVM) and provides visual verification for the vote cast by the voter by printing a slip of paper with the voter's choice on it. The slip of paper with the candidate's detail is briefly displayed for verification behind a glass window, giving the voter 7 seconds before dropping into a compartment below. Voters are now allowed to take the VVT PAT slips home as it is used to verify votes in 5 randomly selected polling booths. The concept aims to enhance trust in the voting process by enabling physical verification of electronically cast votes, reassuring both voters and political parties about the accuracy of their votes. Reasons for introduction: the concept of VVPAT machine was initially proposed in 2010 during a meeting between the Election Commission of India and the political parties to enhance transparency in the EVM based polling process. Following prototype preparation, field trials were conducted in Ladakh, Thiruvananthapuram, Cherrapunji, East Delhi, Jaisalmer in July 2011. It led to the approval of VVPAT by an expert committee of the Election Commission of India in February 2013. Legal aspect. In 2013, the Conduct of Election Rules 1961 were amended to allow for a printer with a drop box to be attached to the EVM. The VVPAT was first used in all 21 polling stations of Noksen Assembly constituency of Nagaland in 2013, leading to its phased introduction decided by the ECI with 100% adoption by June 2017. Supreme Court's view on VVPAT. In Subramanian Swamy versus Election Commission of India case 2013, the Supreme Court mandating VVPATs for transparent election, compelling government funding for their implementation. In 2019, a petition was moved to the Supreme Court asking for a minimum 50% randomized VVPAT slips to be counted. However, the Election Commission of India (ECI) raised concerns regarding the challenges posed by counting 50% of VVPAT slips, including a potential delay of 5 to 6 days in declaring election results, and infrastructure limitations such as availability of manpower. What does the statistical data say about VVPAT slips? Initially, the Election Commission used to match VVPAT paper slips of 4,125 electronic voter machines under the 1 EVM per assembly segment rule. This was based on the result of the request made by the Election Commission in 2018 to the Indian Statistical Institute (ISI) to determine a sample size for the internal audit of VVPAT slips with EVM results that is mathematically sound, statistically robust, and practically cogent. As per ISI's calculation, even counting slips from 479 randomly selected VVPATs across the country would guarantee over 99% accuracy. However, the Supreme Court ruled in 2019 that VVPAT slips of 5 electronic voting machines in every constituency should be counted instead of just one EVM for the greatest degree of accuracy and satisfaction in the election process. These 5 polling stations are selected by a draw of lots by returning officer concerned in the presence of candidates or their agents. With the Supreme Court ruling, the ECI has to now count VVPAT slips of 20,625 electronic voting machines. ISI, Indian Statistical Institute, is a prestigious institution of India recognized as an institute of national importance by the 1959 Act of the Indian Parliament. It was registered on 28th April 1932 as a non-profit distributing learned society under the West Bengal Societies Registration Act 1860. ISI, Indian Statistical Institute, was registered on 28th April 1932 as a non-profit distributing learned society under the West Bengal Societies Registration Act 1860. It was founded by Professor Prasant Chandra Mahalanobis in Kolkata. ISI, Indian Statistical Institute, engages in extensive research with contribution to various fields and collaboration with government and industrial entities. It comes under the Ministry of Statistics and Program Implementation. District Election Management Plan. Why in news? In light of the upcoming Lok Sabha elections, the conduct of elections has become increasingly complex and multifaceted, requiring meticulous planning and execution to ensure a free, fair, and inclusive electoral processes. A cornerstone of this planning process is the District Election Management Plan (DEMP). Why is the District Election Management Plan? DEMP is a comprehensive document that uses statistics and analysis to ensure the smooth conducting of elections in districts. Preparation. According to the directives of the Election Commission of India, The DEMP must be formulated at least 6 months before the tentative date of polling. The dynamics of the electoral processes often necessitate periodic reassessment and modification of the plan after the official announcement of elections. The executive, the election, executive, effective executive execution of the district election management plan entails a coordinated endeavor involving electoral officers, administrative bodies, law enforcement agencies, and other pertinent stakeholders. Scheduled engagement with political entities and media outlets are also arranged to provide them with comprehensive briefing on electoral regulations and procedures. What are the elements of district election management plan? District profile. District profile is the foundational element of the electoral strategy, incorporating a political map delineating constituencies, pertinent demographic and infrastructure statistics, and an overview of the direct district's administrative structure and socio-economic characteristics. Polling station infrastructure. Detailed strategies are devised to enhance the availability and accessibility of polling stations, ensuring essential amenities such as ramps, electricity, lighting, drinking water, toilets, internet connectivity. Special provisions are made for voters with disabilities and senior citizens, including the establishment of help desk, 24/7 control rooms, home voting options, advanced postal ballot voting for essential service personnel. Election Commission of India Autonomous Constitutional Authority administers union or state election, Lok Sabha, Rajya Sabha, state local legislative assembly, offices of the President and Vice President, established on 25th January 1950, National Voters' Day. 25th January is known as National Voters' Day. Provisional Constitutional Provision Part 15, Article 324 to 329. Structure of 1 Chief Election Commissioner, 2 Election Commissioner appointed by President, tenure 6 years up to the age of 65 years, whichever is earlier. Retiring election commissions eligible for further appointment by the government. Removal of CEC, resolution on the ground of proven misbehavior or incapacity, with majority of 2/3 members present and voting, supported by more than 50% of the total strength of the House. EVM management. Electronic voting machine management is crucial for maintaining the integrity of the electoral process, with plans necessary for secure storage and availability of EVMs and voter verified paper audit trials, including plans for their transportation and maintenance. Systematic voter education and electoral participation plan. It focuses on augmenting electoral participation by analyzing voter turnout data to identify polling stations with subpar or notably low participation rates. It involves leveraging social media platforms, engaging with diverse community and youth organization, and organizing awareness, raising events leading up to the polling day. Personal planning and training. The district election management plan outlines a comprehensive strategy for the recruitment, training, welfare, and deployment of election personnel. It emphasizes the necessity of establishing a robust database for poll personnel, categorizing them by cadre and group, assessing their deployment requirements, while devising strategies to bridge gaps in personnel across various election roles. The plan incorporates training programs for district level teams to enforce the Model Code of Conduct (MCC) and provides comprehensive training for all election personnel to ensure they possess the requisite skills and knowledge for their respective roles. Constitutional morality. Why in news? The recent arrest of a serving chief minister on corruption charges raises legal, political, and constitutional concern and poses question about its consistency with constitutional morality, especially in a parliamentary democracy like India. What is constitutional morality? Above, constitutional morality is a concept that refers to the principle and values underlying a constitution that guide the action of both the government and the citizenry. The concept of constitutional morality was propounded by British classicist George Grote in 19th century. He described CM as a paramount reverence of the form of constitution of the land. In India, the term used by Dr. CM means constitutional morality as the paramount reverence of the form of constitution of the land. In India, the term was first used by Dr. B.R. Ambedkar, constitutional morality. Pillars of constitutional morality, constitutional values, upholding the core values enshrined in the constitution, such as justice, liberty, equality, fraternity, secularism, dignity of the individual, rule of law, upholding the supremacy of the law, where everyone, including government officials, is subject to law, accountable under the law. Democratic principle, ensuring the functioning of a representative democracy where citizens have the right to participate in decision making processes and hold their elected representative accountable. Fundamental rights, respecting and protecting the fundamental rights guaranteed by constitution such as right to equality, freedom of speech and expression, right to life and personal liberty, etc. Separation of power, maintaining the separation and balance of power between the legislative, executive, and judicial branch of government to prevent any one branch from becoming too powerful. Checks and balances, establishing mechanism and institution that provides checks and balances to prevent abuse of power and protect the rights of individuals. Constitutional interpretation, interpreting the constitution in a manner that promotes its underlying principles and values while adapting to changing societal needs and circumstances. Ethical governance, ensuring ethical conduct in governance, transparency, accountability, and integrity in public service. Conditional morality and Indian Constitution. The term constitutional morality is not explicitly mentioned in Indian Constitution. However, the concept is inherent in the document's core principle, emphasizing values like justice, equality, and liberty. These principles are found throughout the Constitution, including the preamble, fundamental rights, directive principles of state policy. Its essence is also reflected in various Supreme Court's judgments. Judgments upholding constitutional morality. Kesavanand Bharati vs. State of Kerala, 1973. The case established the basic structure doctrine, which essentially limits Parliament's power to amend the constitution and ensure its core principles remains intact. This can be seen as an early instance of the court upholding the spirit of constitution. S.P. Gupta case, first judge case 1982, the Supreme Court labeled a constitutional bench as a severe violation of constitutional morality. Naj Foundation versus Government of NCT of Delhi, 2009. This judgment decriminalized consensual same-sex relationship between adults. The court emphasized that constitutional morality should prevail over societal perceptions of morality, upholding individual rights. Manoj Narula vs. Union of India, 2014. Supreme Court stated that constitutional morality means to bow down to the norms of the Constitution and not act in a manner which would become violative of the rule of law of action in an arbitrary manner. Indian Young Lawyer Association vs. State of Kerala, Sabrimala case 2018. The court struck down the practice of excluding women of a certain age group from Sabrimala temple. This emphasized that constitutional morality includes principle of justice, equality, liberty, and fraternity, which outweighed religious customs restricting women's entry. Navtej Singh Johar vs. Union of India, 2018. This case read out Section 377 of the Indian Penal Code, which criminalized homosexuality. Challenges to constitutional morality in India. Political interference. One of the significant challenges is political interference in the functioning of the constitutional body and institution. This interference can undermine the autonomy and impartiality of these institutions, affecting their ability to uphold constitutional values. For example, there has been criticisms surrounding the recent changes in the appointment committee of the Election Commission of India and the amended IT Rules 2023. Judicial activism versus judicial restraint. Balancing judicial activism with judicial restraint is another challenge. While judicial activism can promote the protection of rights, the enforcement of constitutional values, excessive activism can encroach upon the domain of the executive and legislature. And enforcement and compliance. Despite having a robust constitutional framework, ensuring effective enforcement and compliance remains a challenge. Implementation gap, delay in justice delivery, and lack of awareness about constitutional rights among the general populace contribute to this challenge. The Chief Minister in India lack immunity from arrests. Constitutionally, only President of India and Governor of State enjoy immunity from civil and criminal proceeding until the conclusion of their terms. Article 361 of the Constitution stipulates that these officials are not liable to any court for acts performed in discharge of their official duty. However, this immunity does not extend to Prime Minister or Chief Minister, who are subject to the principle of equality before the law as advocated by the Constitution. Despite this, arrest alone does not warrant disqualification. Preventive detention. Why in news? Recently, the Supreme Court has held that advisory board under preventive detention law should not behave like mere rubber stamping authorities for the government. They should act as safety valves that stand between the capricious views of power by the state and the right to personal liberty. What is preventive detention? Background. The law authorizing preventive detention existed in British colonial rule in India since 1818. The Defence of India Act of 1915 was passed on the outbreak of the First World War, and the same was repeated in connection with emergency regulation made during the Second World War. Both have provision of preventive detention, that is, detention of a person without trial and conviction. Preventive detention means the detention of a person without trial and conviction by a court. Its purpose is not to punish a person from a past offense but to prevent him from committing an offense in the near future. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. Grounds for preventive detention: state security, public order, foreign affairs, etc. Two types of detention. Preventive detention is when a person is held in police custody only on the basis of a suspicion that they would conduct a criminal act or cause harm to society. The police have the authority to hold anyone they suspect of committing a criminal offense and also to make arrests without a warrant or magistrate's authorization in certain cases. Punitive detention, which means detention as a punishment for a criminal offense. It occurs when an offense is actually committed or as an attempt has been made towards the commission of that crime. Protection. Article 22 grants protection to persons who are arrested or detained. It has two parts. The first part deals with the case of ordinary law and the second part deals with the case of preventive detention law. The article makes it mandatory for preventive detention law to form advisory board consisting of persons qualified to be High Court judges. Under different laws, review boards must assess detention orders every 3 months to determine if there is enough reason for preventive detention. They analyze evidence, request more information if needed, listen to the person detained, then report if the detention was justified or not. Safeguards available to the detained person. A person may be taken to preventive custody only for 3 months. The period of detention may be extended beyond 3 months only after approval of the advisory board. The detainee has right to know the grounds of his detention or her detention. However, the state may refuse to tell the grounds if it is necessary to do so in the public interest. The detainee is provided an opportunity to challenge his or her detention. The relative preventive laws. Public Safety Act PSA, Narcotic Drug and Psychotropic Substance Act NDPS Act 1985, National Security Act NCRB data showed that the number of people arrested under the National Security Act has dipped significantly compared to 2020. Preventive detention under NSA peaked in 2020 at 741. This number dropped to 483 in 2021. Issues related to preventive detention. Dent to democracy. No democratic country in the world has made preventive detention as an integral part of the constitution as has been done in India. Extrajudicial authority. Government occasionally leverages such laws to exert extrajudicial authority, raising concern about arbitrary detention. Misuse of other acts. There are several laws like the Unlawful Activities Prevention Act 1967 which have potential to be misused for preventive detentions. Manipulation by government officials, district magistrate and the police also often make preventive detention to control law and order in emerging communal clashes or clashes between any two communities, even when it might not always lead to public disorder. Supreme Court on preventive detention. Amina Begum case 2023. The Supreme Court held that preventive detention is an exceptional measure meant for emergency situation and should not be used routinely. The objective of preventive detention is not to punish but to prevent anything prejudicial to the security of the state. Ankul Chandra Pradhan case 1997. This case emphasized that the purpose of preventive detention is to prevent harm to the security of the state rather than to impose punishment. What is public order and law and order? Public order refers to maintenance of peace, stability and harmony within society, ensuring that activities and behaviors do not disturb the overall well-being or safety of the community. Public order is also one of the grounds for restricting free speech and other fundamental rights. Power to maintain public order. Under Entry 9 of List 1 Union List, the Constitution of the India provides Parliament with exclusive power to enact a law for preventive detention for the reasons connected with defense, foreign affairs or security of India. Entry 3 of List 3 concurrent list, both Parliament and state legislature have power to enact such laws for the reason related to the maintenance of public order or maintenance of supplies or services essential to the community. According to state list 2 of the 7th schedule of the Constitution, the power to legislate on the respect of public order rests with the states. Distinction between public order and law and order. Supreme Court distinguished public order and law and order. In Ram Manohar Lohia versus State of Bihar case 1965, the Supreme Court held that the problem of law and order affected only a few individuals, but an issue of public order influenced the community or public at large or even the country. The difference between law and order and public order lies in the degree and extent of their scope. The Supreme Court clarified that to bring the activities of a person within the expression of acting in any manner prejudicial to the maintenance of public order, the activities must be of such a nature that the ordinary laws cannot deal with them or prevent subversive activities affecting societies. Authority of High Court benches. YN News. Recently, the Madras High Court principal seat has reinstated the Madurai bench authority to adjudicate all types of public interest litigation, including those involving matters concerning the entire state rather than just the 13 districts within its territorial jurisdiction. The Madras High Court's principal bench in Chennai has a permanent bench in Madurai which exercise jurisdiction in all matters except original jurisdiction mirroring the principal bench. What is the ruling of the Madras Court? A judgment passed by the former Chief Minister of Madras High Court, Chief Justice of Madras High Court, had emphasized the need of to file PILs regarding temples' interests statewide at the principal seat of the court rather than the Madurai bench focusing on district-specific cases. However, in the recent judgment, the right of the Madurai bench of Madras High Court have been restored to hear all kinds of PIL, including those that concern issues related to the entire state, and not just the 13 districts under its territorial jurisdiction. The court stated that while the Chief Justice can transfer a case from principal bench to the permanent bench, If necessary, a blanket order requiring all pan-state matters to be filed only at the principal seat would not be suitable for the Madurai bench functioning. Legal basis of judgment. The court relied on the presidential notification issued in 2004 for constitution of the Madurai bench that had not imposed any such restriction. The court also noted that a full bench ruling in B. Stalin versus Registrar 2012 clarified that there were no restriction on the type of PIL that could be filed and heard at Madurai bench, although it affirmed the Chief Justice authority to transfer cases between the principal seat and the Madurai bench. What is the process of establishment of High Court and permanent benches? Establishment of High Court. Article 214 of the Constitution of India provides that there shall be a High Court for each state. However, Section 51 of the State Reorganization Act 1956 provides for setting up benches away from the principal seat. Justice Jaswant Singh Commission 1981, a commission was appointed to consider demands for High Court benches in Western District of Uttar Pradesh. The terms of reference was later expanded in 1983 to examine the general question of establishing benches of High Court at places other than their principal seats. Recommendation. The Commission recommended criteria including characteristics of the region, population size, area, means of travel, communication distance for litigants, pendency rates, infrastructure availability, and the legal talent. Supreme Court's position. In a writ petition, the Supreme Court examined the demand for establishing High Court benches at centers other than principal seat, emphasizing that decision should be based on rational, not emotional, sentimental, or parochial consideration. Consensus among the state government, the Chief Justice of the concerned High Court, and the Governor is necessary for setting up benches. Role of Union Government. The government considers proposal for setting up benches only after receiving a complete proposal from the state government with the consent of the Chief Justice and the Governor. State government is responsible for providing infrastructure facilities and bearing the entire expenditure of the High Court and its bench. Chief Justice manages the day-to-day administration of the High Court and its bench, deputing judges from principal seat to the benches as needed. Consultative approach requires consensus among the state government and the High Court is adopted for deciding on setting up benches. Supreme Court has defined a PIL a legal action initiated in a court of law for enforcement of public interest or general interest in which the public or a class of community has pecuniary interest or some interest by which their legal rights or liabilities are affected. Public interest litigation is not defined in any statute or in any act. It has been interpreted by judges who consider the intent of the public at large. Some of the matters that are entertained in the PIL are bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, atrocities on women, environmental pollution and disturbance of ecological balance. Industrial alcohol regulation via news. So this I'll be discussed in other videos. If you find this video useful, like to subscribe. Thank you for watching this video.